Hi everybody. Can Christians be forced to act against their faith? The Obama administration, we can and will force Christians to act against their faith. And this is by Terrence P. Jeffrey, December 29th, 2012. David and Barbara Green of Hobby Lobby. Now, I'm only going to read a portion of this, and then it's up to you to go and read the rest of it. CNSnews.com. In a legal argument formally presented in federal court in the case of Hobby Lobby versus Kathleen Sebelius, the Obama administration is claiming that the First Amendment, which expressly denies the government the authority to prohibit the free exercise of religion, nonetheless allows it to force Christians to directly violate their religious beliefs, even on a matter that involves the life and death of innocent human beings. Because federal judges, including Supreme Court Justice Sonia Sotomayor, have refused to grant an injunction protecting the owners of Hobby Lobby from being forced to act against their Christian faith, those owners will be subject to federal fines of up to $1.3 million per day starting Tuesday for refusing to include abortion-inducing drugs in their employee health plan. The Obama administration is making a twofold argument for why it can force Christians to act against their faith in complying with the regulation it has issued under the Obamacare that requires virtually all health care plans to cover without copay sterilizations, contraceptives, and abortion-inducing drugs. The first argument The first argument the administration makes against the owners of Hobby Lobby is that Americans lose their First Amendment right to freely exercise their religion when they form a corporation and engage in commerce. A person's Christianity, the administration argues, cannot be carried out through activities he engages in through an incorporated business. Hobby Lobby is a for-profit secular employer and a secular entity by definition, does not exercise religion, said Acting Assistant Attorney General Stuart Dellery in filing submitted in the U.S. District Court for Western District of Oklahoma. Because Hobby Lobby is a secular employer, it is not entitled to the protections of the Free Exercise Clause or RFRA, the Religious Freedom Restoration Act. Dellery told the court on behalf of the administration, this is because although the First Amendment freedoms of speech and association are rights enjoyed by religious and secular groups alike, the Free Exercise Clause gives special solicitude to the rights of religious organizations. In keeping with Dellery's argument, the Washington Post, as a corporation, can use its First Amendment protected speech, freedom of speech, to write editorials in support of the Obama administration imposing its contraception mandate on businesses like Hobby Lobby. But the members of the family that created and owns Hobby Lobby, because they formed Hobby Lobby as a corporation, have no First Amendment freedom of religion that protects them from being forced by the government to act against their religious beliefs in providing abortion-inducing drugs. The second argument the administration makes to justify forcing Christians to act against their faith is more sweeping. Here the administration argues it can force a person to act against his religion so long as the coercion is done under the authority of a law that is neutral and generally applicable. In other words, as long as the law was not written specifically to persecute Christians as Christians, the government can use that law to persecute Christians. Okay, so bottom line is, if you're a corporation, business corporation, you have no rights. You have to follow along with the Obama administration health plan, with the sterilizations, contraceptives, and abortion-inducing drugs. So you have to incorporate those in your health care plans. Unfortunate for these people, because they do practice their Christian religion in faith. And if you want to read more on this article, the link will be below the video. Thanks for listening, and I'll see you next time. God bless.